The Criminal Code Amendment Act 2013, which was passed in the House on Thursday, March 13th, is inextricably linked with the Computer Misuse and Cybercrime Act 2013. This was confirmed by Premier Dr. Orlando Smith when he spoke on the bill in the House of Assembly.
And Speaker, this bill essentially will be consequential upon the Computer Misuse and Cybercrime Act of 2013, which, if passed into law, will speak to the same matters which are currently dealt with under the Criminal Code. Therefore, in order to remove the potential conflict between the two pieces of legislation, the Criminal Code is amended to revoke its provisions dealing with the matters that are the subject matter of the Computer Misuse and Cybercrime Act 2013.
In his contribution to the debate on the Criminal Code Amendment Act, opposition member for the 3rd District, Julian Fraser, suggested that the Criminal Code Amendment Act was preempting the Computer Misuse and Cybercrime Act and questioned the order in which the bills were being tabled in the House of Assembly before being sent to the governor for assent and signed into law.
I see us preempting a decision by the governor. We presupposing what he is going to do. What happens if this piece of legislation, if the governor doesn't assent to the amendment to the criminal code? What do we come back here again to remove that section from the cyber legislation?
Similar queries were raised by opposition leader Ralph O'Neill and opposition member for the 1st District, Andrew Foy. Attorney General Dr. Christopher Malcolm explained why the procedural approach was being taken to have the Criminal Code Amendment Act 2013 passed in the House of Assembly.
Madam Speaker, the fact is that all laws passed here are subject to assent by the governor. So the point is that if he does not assent, the status quo remains. Meaning the position with the criminal code being unaffected would remain without that assent being granted.
What about the cyber legislation?
And similarly, in relation to the cyber legislation, even if it is passed here, if it doesn't receive an assent, it has no value. It doesn't become law, which we can act upon without the assent.
Deputy Premier Dr. Kedrick Pickering noted the separation of powers between the legislative, judicial, and executive arms of government in the Westminster system of government, as he noted the objectivity required by the governor in his acquiescence of bills sent before him.
The governor can't decide not to assent to a piece of legislation just because he doesn't want to assent. There are clear, procedural rules and regulations that gives power under what conditions the laws cannot be assented to. So I don't want our listening public to get the impression that if the governor sits in his office and he don't like what the House of Assembly is doing, he has power to decide. It can't happen. Because as far as I'm aware, that's not the way the system works. And the whole question of separation of powers exists to deal specifically with those issues. There's a separation of the executive and the legislative branch of government. The governor represents Her Majesty the Queen. And as far as I can remember and recall about these issues, any law that we pass locally cannot interfere with any other substantial legislation or anything that affairs with the functioning of Her Majesty's government. So there are clear rules under which the governor can have the power not to assent to legislation, but he can't sit down there and decide he ain't like what we're doing and he assenting to it. I don't want the general public to get that impression. So whether we are taking the Cybercrime Act before or whether we take this before, we're going to do them one behind the other anyway.